Dear students, I welcome you all to this lecture. Today's topic for discussion is compromises, arrangements and amalgamations. The main aim of this lecture is to develop an in-depth understanding of compromises and arrangements and the prescribed procedure for the scheme of compromises and arrangements under the Companies Act of 2013. And also the various aspects and conditions necessary for the compromises and arrangements in India under the Companies Act of 2013. After going through this lecture, you should be able to understand the meaning and the purpose of corporate restructuring, understand the meaning of compromises and arrangements under the Companies Act of 2013, and understand the prescribed procedure of compromises and arrangements. Dear students, in this segment we will try to enhance our understanding of the concept of compromises and arrangements by extensively looking at their meaning, definitions and procedure to be followed, which is recognized under the Companies Act of 2013. Amalgamations, compromises, arrangement or reconstruction are all different forms of corporate restructuring exercises in the corporate world. All these activities are governed by regulations in different countries. Corporate restructuring is a collective term for a variety of different business transactions. The companies are required to take approval from various regulatory authorities and adhere to various legal provisions. Considering various issues involved in the cross-border mergers and acquisitions, it becomes tedious and difficult to get the approval under every regulation and under every act. Corporate restructuring in any form has become a mandatory activity if the corporate houses have to survive. Corporate restructuring might result in change, generally like change in share capital or capital structure, change in shareholders, change of control, removal of a minority, change of business, change of operating entities, etc. Corporate restructuring is basically a business decision. In the words of Justice Dhananjay Chandrachud, corporate restructuring is one of the means that can be employed to meet the challenges and the problems which confront business. The law should be slow to retard or impede the discretion of corporate enterprise to adapt itself to the needs of changing times and to meet the demands of increasing competition. The law, as evolved in the area of mergers and amalgamations, has recognized the importance of the court not sitting as an appellate authority over the commercial wisdom of those who seek to restructure business. A company can partially or fully reorganize or restructure itself, either through internal reconstruction or external reconstruction. Compromise or arrangement falls under the internal reconstruction, whereas amalgamation falls under the external reconstruction. Internal reconstruction. Internal reconstruction is an arrangement made by the company in which, wherein changes are made within the company to the assets or liabilities of the company in order to improve the profitability of the company, for example, reduction in share capital, conversion of shares in the stocks or vice versa, or consolidation of shares, etc. External reconstruction. It is a process of liquidating the existing company and transferring all of its assets and liabilities to another newly formed company. Corporate restructuring or reconstruction can be categorized under various heads such as debt and capital restructuring, internal and external restructuring, organic and inorganic restructuring. Sections 230 to 240 of the Companies Act 2013, read with the Companies, Compromises, Arrangements and Amalgamation Rules of 2016, deals with the subject of amalgamation, arrangements and compromises, while Section 230 and 231 deal with the compromise and arrangement. Sections 233 to 240 speak about merger and amalgamation. Now, let's discuss the meaning and the definition of compromises and arrangements. The term compromise itself denotes the presence of a dispute. Dispute may be between a company and its creditors or any class of them, or maybe between a company and its members or any class of them. Such a dispute may be resolved by drawing up a scheme of compromise, provided it must be a reasonable one. It must be beneficial to both the sides. Surrendering everything without gaining anything is not a reasonable compromise. The term arrangement has a wider meaning. It includes arranging or changing the share capital or capital structure. It may also denote the modification of rights and liabilities. This is possible even without the existence of any dispute. Hence, where there is no dispute, but there is a need for modification or rearrangement of rights or of liabilities of creditors or a class of them, or of members or class of them, the company may resort to arrangement. The word compromise has nowhere been defined in the Companies Act. It basically connotes the settlement of a conflict by mutual consent and agreement, or through a scheme of compromise. Thus, for a compromise, there has to be some dispute or conflict. On the other hand, the word arrangement has been defined under Section 230, Clause 1 of the Companies Act. The arrangement has a wider connotation than compromise. The arrangement means reorganizing the rights and liabilities of the shareholders of the company without the existence of some dispute. A company may enter into a compromise or arrangement to take itself out from the winding up proceedings. The term arrangement has been given a wider scope under the Companies Act 2013. According to Section 230 of the Companies Act 2013, an arrangement includes a reorganization of the company's share capital by the consolidation of shares of different classes, or by division of shares into shares of different classes, or by both the methods. The Act enunciates two possibilities of scheme of arrangement. They are between a company and its creditors, and between a company and its members. The situations under which a company may call for a scheme of compromise are: if, in the normal course of business, it becomes impossible to pay all the creditors in full; subsidiaries or units cannot work without incurring losses; where liquidation of the company may prove harsh for the creditors or members. The situations under which a company may enter into the arrangements are: for the issue of new shares, for any variation in property, conversion of one class of shares to another, for reorganizing the share capital of the company, or a scheme of arrangement with members for amalgamation and mergers is clearly distinguishable from a mere scheme of compromise with creditors. The primary difference between a compromise and an arrangement is that whereas an arrangement is between a company and its members or class of members, a compromise is between a company and its creditors or class of creditors. Another distinguishable feature that is in case of a compromise, there is an element of dispute present as it is done between a company and its creditors. But in case of an arrangement, there is no such element of dispute present. After the enactment of the Companies Act 2013, the procedure for mergers, acquisitions, amalgamations and restructuring has been simplified by the new provisions. The Act of 2013 has removed all the backdrops of the older legislation and is aimed to bring more transparency. It allowed cross-border mergers as well, increasing the horizon for the industries and making it easier for them to expand. In order to speed up the process and to bring more transparency, the assistance of tribunal was invoked under the 2013 Act. So, now we have understood the concept of compromises and arrangements and the points of difference between them. Let's move forward and understand the stepwise procedure to be followed for the scheme of compromises and arrangements under the Companies Act of 2013. First is preliminary stage or preparation of the scheme. This is the first stage in which a detailed scheme is prepared by the company members of the creditors. This scheme must contain all the matters that are of substantial interest. It must also explain or show how the scheme is going to affect the members, creditors, and all the other companies. The scheme must also disclose the material interest of the director. Second is application to tribunal. Any member or a creditor of the company, in case the company is winding up its liquidators, can make an application to the tribunal, that's NCLT, National Company Law Tribunal, proposing the scheme of merger or acquisition between two or more companies. The tribunal can also make the application on a suo motu basis. The application to the tribunal to disclose by affidavit all material facts relating to the company, such as the latest financial position of the company, the latest auditor's report on the accounts of the company, and the pendency of any investigation or proceedings against the company. Then, reduction of share capital of the company, if any included in the compromise or arrangement. Any scheme of corporate debt restructuring consented to by not less than 75% of the secured creditors in value, including first, a creditor's responsibility statement in the prescribed form. Second is safeguards for the protection of other secured and unsecured creditors. Report by the auditor that the fund requirements of the company after the corporate debt restructuring as approved shall conform to the liquidity test based upon the estimates provided to them by the board. Where the company proposes to adopt the corporate debt restructuring guidelines specified by the Reserve Bank of India, a statement to that effect. And a valuation report in respect of shares and the property and all assets, tangible, intangible, movable, immovable, of the company by a registered valuer. Tribunal looks into the application. Once an application proposing the scheme is made, the tribunal will take a look at as to whether the application is within the ambit of section 230 to 240. It is pertinent to note here that in this stage, the tribunal is not concerned with the merits of the application. It will only look as to whether the application is within the ambit of the act or not. It will also see that the application is accompanied by an explanatory statement. Conveyance of meeting by notice. Once the tribunal sees the application, it issues a notice for the conveyance of the meeting of the creditors and the members of the company within 21 days. It must be noted that if the scheme is not going to have an adverse effect on any party, then the tribunal can also avoid the call for meeting. If the meeting is convened, then the scheme must be approved by a majority of 3/4 members present and voting. Another important requirement is that the notice of such meeting as proposed to be called under this section shall be sent individually to all the creditors and the members and their classes thereof, and also to the debenture holders of the company. Section 230 clause 5 of the Company Act provides that a notice along with prescribed documents shall also be sent to the central government income tax authorities, RBI, that's Reserve Bank of India, SEBI, Security and Exchange Board of India, respective stock exchanges, Official Liquidator Competition Commission of India, that is CCI, if necessary, and such other sectoral regulators or authorities likely to be affected by the compromise or arrangement. And these authorities shall make their representations, if any, within 30 days of receipt of such notice. If these sectoral regulatories or authorities do not make any representations within the prescribed time period, it shall be presumed that they have no representation. Presentation of the outcome of meeting before the tribunal. Once the scheme is approved by the members or creditors or the liquidator in the meeting, the report of the meeting must be presented before the tribunal within 7 days of meeting. The report must show the confirmation of the scheme of compromise or arrangement. Commencement of hearing. After the submission of the report of the tribunal shall fix a date for hearing. Such date must be notified in the newspaper through advertisement. Such advertisement must be notified before 10 days of the hearing. Now, power of tribunal to enforce compromise or arrangement. The tribunal shall, after hearing all the objections and concerns of all the parties, if it is deemed fair and reasonable to the tribunal, then the tribunal may sanction the compromise or arrangement. Section 231 is a distinct provision and is similar to Section 392 of the Companies Act of 1956. The role of the tribunal is not only inquisitorial or supervisory role, but also a pragmatic role which required forming of an independent judgment, so as to ensure proper working of the scheme. The legislative purpose behind conferring power of the widest amplitude on the High Court under Section 392 of the previous Act was not only to give directions, but to make such modifications in the compromise and arrangement as the court may consider necessary. The only limit on the power of the court being that such direction can be given and the modifications can be made for the proper working of the compromise or arrangement. The purpose underlying this is to provide for the effective working of the compromise and arrangement. The tribunal, similar to High Court, has the power to implement the order of compromise or arrangement. It may, at the time of making such order or at any time thereafter, give such directions in regard to any matter or make such modifications in the compromise or arrangement as it may consider necessary for the proper implementation of the compromise or arrangement. The tribunal has also been given power to order winding up of the company if it is satisfied that the compromise or arrangement sanctioned under 230 cannot be implemented satisfactorily with or without modifications and the company is unable to pay its debts as per the scheme. Such an order shall be deemed to be an order made under section 273. Registration of the scheme with registrar. According to section 230 clause 8, once the scheme is sanctioned by the tribunal, a certified copy of the order shall be filed with the registrar of company within 14 days from such sanction order. In addition to the prescribed procedure for the compromise and the arrangement, we also need to understand the important powers and duties of National Company Law Tribunal. Powers and duties of the tribunal are: before understanding the powers and duties of the tribunal, that's National Company Law Tribunal, it must be understood as to why is the sanction of tribunal important. There are several reasons which necessitate the sanction of the tribunal. A few of them are: once the scheme is approved by the tribunal, the company is bound to abide by it. Any avoidance or deviance from same may bring legal consequences. If the tribunal won't have interfered, the majority might have suppressed the minority's rights. So, tribunal ensures adequate representation of the minority. Tribunal also has supervisory powers. So, at any time if tribunal is of the view that the scheme is not in the interest of the members, it may order to modify the scheme or may order winding up. The tribunal is empowered with a wide range of powers by the virtue of section 231. The tribunal has the sole authority to either to approve or to reject the scheme of compromise or arrangement. If the tribunal approves the compromise or arrangement, in such case, the powers of the tribunal are: first, to supervise or monitor the carrying out of the proposed scheme. Then, second, to modify or amend the scheme to achieve the best result. To order winding up of company under section 273 of the Companies Act of 2013. If it is deemed to the tribunal that the scheme is not workable in the interest of the company or its members. Apart from these powers, the tribunal is also bound by certain duties. So, whenever the tribunal sanctions a scheme, it must make sure that the scheme is within the provisions of the Companies Act 2013. The tribunal must make sure that the class of people who are to be adversely affected by the scheme are fairly being represented in the meeting. The proposed scheme must be reasonable. It should not have any adverse effect on society. Dear students, I hope you have developed a wholesome understanding of the concepts of compromises and arrangements, their definition, characteristics, and the implementation procedure to be followed, which is established under the Companies Law and recognized by the Companies Act of 2013. With this, we wrap up today's lecture, and I hope you enjoyed this lecture. Thank you, and I wish all of you good luck.